Misfiling your FBAR, you're not alone, but how you fix it can determine whether you pay a penalty or face criminal charges. I'm attorney Chad Silver, founder of Silver Tax Group. We've helped hundreds of clients across the country and internationally fix past FBAR mistakes, reduce penalties, and avoid prosecution. Call us now at 855-900-1040 or visit us at www.silvertaxgroup.com for a confidential FBAR strategy session. We build your defense, we implement your filings, and we defend you if necessary. How to fix a late or missed FBAR without going to jail. Quiet disclosure, high risk. Let's start with the worst way to fix a missed FBAR, a quiet disclosure. That's when someone tries to file old FBARs without telling the IRS, without using a formal program, hoping to fly under the radar. It's risky. The IRS has said quiet disclosures can trigger audits and even criminal investigations if they think you acted willfully. Don't go this route without legal advice. It's not worth the risk. However, in some cases, quiet disclosures could be appropriate. Streamlined procedures, best for non-willful cases. If you made a non-willful mistake, like you didn't know about the FBAR requirement, you hired a CPA who didn't really go thoroughly through your financial statements or ask you about foreign accounts, or maybe the CPA clicked the wrong button on your Schedule B, you may qualify for the Streamlined foreign or domestic offshore procedures. This is often referred to as the IRS's FBAR amnesty program. You file your last 3 years of returns or amended returns. File 6 years of FBARs. Certify that your non-compliance was not willful. Those penalties are either reduced or significantly waived entirely, especially if you live outside the U.S. We've helped clients through this process with zero penalties. The Voluntary Disclosure Program, VDP. Now, if your failure to file FBARs was willful, meaning that you knew about the requirements and didn't comply, you need to look at the IRS Voluntary Disclosure Program, or VDP. This program is for higher risk cases, but it may be the only way to avoid criminal prosecution. You'll need to disclose all the offshore accounts, file amended returns and FBARs, pay back taxes, interest, and penalties. But the benefit? You'll avoid jail, and you get the IRS off your back permanently. There's a very specific way to go about doing the VDP disclosures. How far back do you need to file? Generally, the IRS wants 6 years of FBARs and 3 years of amended returns if you're using streamlined procedures, and possibly more depending on your situation. We'll help you gather the right records, draft the right statements, and submit the entire package correctly the first time. When to hire an FBAR tax attorney. If you have over 10,000 in foreign accounts and missed even 1 year, it's time to call a qualified FBAR tax attorney, not just a CPA. Why? Well, because once the IRS believes your conduct was willful, you're in criminal territory, and only a tax attorney can protect your rights. At Silver Tax Group, we do more than the paperwork. We defend you if necessary and keep your name out of the hands of the DOJ. Don't guess, don't go silent, and don't go alone. Call Silver Tax Group today at 855-900-1040 or visit us at silvertaxgroup.com. We'll guide you through the FBAR correction process the right way, the safe way, the legal way. We build it, we implement it, and we'll defend it if necessary.